the general election campaign period was dominated by relentlessness, targeting the opposition and its leadership, their candidates, their supporters. And across multiple districts and across the country, we witnessed opposition campaign activities being blocked, violently dispersed, or subjected to excessive police and military force. We saw heavy presence of the military in the electoral processes across the country, which we believe is a concern. And we took note of that. We had to document that. Particularly in some districts, the opposition candidates were not even allowed to campaign or hold their rallies. And the report highlights the examples and the names and the areas with clear facts and figures. We also witnessed killings during this election period. In Tambala district, for example, reports show that 7 people were killed at the home of the former MP, Mwanga Chivumbi, on the 15th of January. This was the day after the elections. And what is really absurd and perturbing is the fact that we've not even seen or had the police investigating these deaths or trying to hold anyone accountable for having, because we know there was a shooting, people are shot and dead. Instead, the cases we are seeing are, against Mwanga Chivumbi and the other people, but we've not seen any investigations be conducted, meaning there's a deliberate move to avoid accountability, similar to what we saw in the previous elections, 2021, where people were killed, but up to now, we've not seen that accountability. No one has ever been held accountable, despite the fact that we had over 50 Ghanaians dying in the system. And again, so many other reports in Kayunga, Nurwaga, someone who was just shot in Dagire, who was shot on her way moving from voting. In Romiaga, Zimbabwe, we saw 2 people being shot dead. In Bukedi North and so many other areas, we have all those details in the report. And there are quite a number. Now, that was also coupled by several arrests, abductions, and detentions of various people, specifically opposition supporters. We had reports in Mbaro of over 80 people who were arrested in Arua, in Mitiana, Lango sub-region, in Iganga, and so many others. So that is really a concern and a rule of law issue that we need to address as a country. The second part is also we've witnessed abductions and continued enforced disappearances during this reporting period. It's as if we've normalized this process. We've normalized abductions, we've normalized enforced disappearances, and it is a human rights concern. It's a rule of law concern. This period has been marked by a disturbing increase in enforced disappearances and arbitrary arrests of political actors, lawyers, government critics. In several cases, individuals were seized by armed military personnel, even those that are not armed, rather that are not in military uniform, but considered to be security operatives by appearance and by their actions. People being held in undisclosed locations without access to their lawyers, their families, their doctors, only to be produced in court days later. Now, these incidents undermine the constitutional guarantees of personal liberty, due process, and protection from arbitrary detention. Now, in some of these cases, we've seen people have applied for habeas corpus. You see government come out and deny, saying, no, we do not have this person. And days later, the same person who government denied having is produced in a court of law. He's taken through the police, through, the courts of law, charged with offenses, and then subsequently remanded to prison, which has increased on what we've been talking about, the police to prison pipeline. Every other day we've been coming here talking about the problem of prison congestion, the numbers, and what are the causes. But now the situation in this reporting period has moved from police to prison pipeline to abduction to prison pipeline. Because ultimately that's where these people end. The unfortunate bit is that these institutions that should question some of these actions do not do that. When someone is presented in court, we expect the judicial officer to question, especially once it is raised, to be concerned about how this person reached here. We had reports of abductions. Yet, like I said before, I have all these legislations talking about due process. You know, when someone is alleged to have committed an offense, what should be the process, regardless of what the offense could be, even if it's murder. But the fact that we're gradually allowing to use wrong means and abuse rights, it's really concerning. Several examples, you know about Lena Zedriga Waru, Jolly Tumshabe, and John Mary Sebufu. These being NUP people, I believe all of you followed the stories. These are deputy presidents, Zedriga being from the north, deputy presidents of NUP, Jolly being from Barara, who were abducted, you know, by a group of masked men, disappeared for some days, and later produced and put in the system. We've increasingly seen the scenario of Sam Mugumya, who was equally abducted last year, but even this year, the colleagues that continued searching for his whereabouts, it's nowhere to be seen. Again, recently we saw Honorable Miriam Matembe, a former minister, a member of parliament and human rights activist, who was also forcibly abducted from her relative's home by armed men. Her whereabouts were unknown for about 2 weeks. The husband attempted to go and report at police, 2 police stations. The aspect of his wife missing was ignored, and then later she's produced in court and charged with an offense. These are blatant abuses of human rights that should concern us as a country. We've seen also, again, disturbing trends. Honorable Elias Rukwago on the 15th of June, 2026, who is a senior advocate and also legal representative for retired Colonel Dr. Kizza Besigye, who was also taken from his home in Wakaliga by armed security personnel. And for approximately 2 days, his whereabouts remained unknown. His family and lawyers are denied access. And during this period, we observed photographs purported to be of him in the basement, being tortured, being mistreated. And then later, he was handed over to the police. Recently, I received a call from one of my uncles in the village who asked me that, but you people, you Law Society, why don't you now go and you get these police officers who receive people who have been abducted? Why don't you get them? They're the ones you should hold accountable. Why do they allow to receive these people and open files against them? And for me, I felt even an ordinary person understands what accountability means. But we seem to be closing our eyes to all this. We've all seen the situation of Mwanga Chivumbi, also a member of parliament for Butambala County, who had been in custody since 22nd January on terrorism charges, was granted bail by the court, and shortly, less than 24 hours later, he's abducted and again also detained in an undisclosed location. This was done in broad daylight. He remained in incommunicado detention for over 19 days before being produced in a Utambara court. Same process, same system, and we are still normalizing it. We say seemingly we are normalizing impunity and lawlessness. Now, we have several, of course, these cases reflect a broader pattern in which security forces and agencies have increasingly resorted to unofficial detention, prolonged incommunicado confinement, and delayed production of suspects before court. And these actions do not only violate the Constitution, the constitutional provisions, but also erode public confidence in the rule of law by undermining due process, judicial oversight, and accountability for abuse of power. it's more or less an overthrow of the Constitution, because you can no longer cite the Constitution anywhere and you're taken serious. People need to have confidence in these processes. There needs to be certainty. But all these incidents that we see happening are leading to that challenge. No wonder we are beginning to see increased cases of lawlessness on the streets, where people are dying to mob justice because people believe probably they can take the law into their hands, and it is normal. It is a dangerous situation. Now, the recommendations we laid down there, well, I'll mention that the security agencies should immediately cease the practice of abducting, I'm not using the word arresting, and detaining persons in undisclosed locations. All arrests should be conducted in accordance with the law. They know the laws. Again, also to the DPP should decline to sanction charges where the prosecution is founded on unlawful arrest or detention, and strengthen scrutiny of files involving persons brought after abductions. Again, also the police should stop receiving and legitimizing persons brought into police custody after abduction. Police should establish a document who arrested the person, where, when, and under what authority, so that there's accountability. We also recommend that government must comply with ratified international law prohibiting disappearances, detention in ungazetted areas, and torture, because we are seeing this increasingly happening, and it's the duty of government to have a social contract between the people and the government. And again, lastly, the judiciary must comply. The judiciary should exercise robust scrutiny over cases involving persons who are presented before court after periods of incommunicado detention, including investigating all these allegations. Some of them could be allegations, but it's the role of the judiciary to investigate allegations of torture and lawful arrests and violations of rights of these people. Then number 2, under that, after abductions and continued disappearances, freedom of expression, freedom of press, and the right to information. Now, freedom of expression, earlier we reported on the positive, but we also have the negative part of it. This is the right to receive and impart information, and digital rights remained under significant pressure during the reporting period, despite the fact that we have these constitutional provisions. We've seen journalists, civil society organizations, political activists, digital content creators, and ordinary citizens continue to report intimidation, censorship, surveillance, arrests, and restrictions on online and offline expression. Public assemblies and civic activities also remain subject to extensive regulation and disruption on ground of public order and national security. If you remember, in the wake of the elections, we saw the internet shut down across the country, despite the fact that promises had been made that it would not happen. And what is always cited is national security. That's, I think, the same time we also saw the suspension of civil society organizations. Now, the first aspect, like I said, being the electoral period where we had internet shutdown and assault of journalists, we saw restrictions on access to information through the use of internet shutdown, which was on the 13th, by the Uganda Communications Commission, which directed all telecommunication operators to shut down the service. So citizens were not able to access information during that time. Press freedom also experienced significant setbacks. We saw during elections and the campaign period, deliberate assault of journalists, which was a critical issue for journalists being beaten, assaulted, and attacked. Some of them cameras, mobile phones, memory cards, and other reporting equipments were confiscated or destroyed. And we also know that several journalists were arbitrarily arrested and detained, despite clearly identifying themselves as members of the press. Clearly. So this was a concern to us. On the aspect of abductions and detention of journalists, during this period, we saw several of them. For instance, journalists that were covering the proceedings at the General Court Martial who were detained by UPDF personnel. These included Judith Kukunda, Christina Batanzi, Margaret Zarwango, their phones, cameras, and other equipment taken away. We've seen similar incidents. Recently, journalist Timothy Karejira was arraigned in court and remanded to Ruzira on charges of broadcasting without a license under the Uganda Communications Act. This is a similar challenge we are facing with Male Mabirizi. Though he's not a journalist, but we are seeing these laws, we call it lawfare, increasingly being used. And several other journalists on 29th March, we saw the Digitalk journalist Arnold Anthony Mukose, who was reportedly abducted shortly after appearing on a radio talk show in Kampala. And this was done by men in plain clothes. So this is concerning because the fourth estate should be protected. Journalism is not a crime. They are simply doing their work and providing information. And the third part under that is suspension of operations of media group. And we believe that the violation of media freedom further escalated by the shutdown of operations in June 2026 of the NMG Group, one of the country's largest independent media organization, NTV, Daily Monitor, Spark TV, and the rest, where they woke up in the morning and soldiers were deployed at the company's premises in Namgongo, preventing them from entering. Of course, it is an issue that has been around. It is not until recently that they resumed operations. But the Minister of ICT and National Guidance indicated that the closure was connected to an ongoing security investigation ordered by the head of state. Now, we know the discussions went on, the operations were opened, but then our concern is that this censorship is a major attack on media independence, which we should all respect. The absence of any publicly communicated legal basis for the closure, together the reports that negotiations involving political actors to determine whether the media houses will be allowed to resume or not, is something that we should consider unacceptable because we have regulations and there are processes and due process. This does not recognize due process. Again, there's continued targeting of online expression, specifically speaking to the case of Male Mabirizi, who is currently detained and is still ongoing trial, is incarcerated at Ruzira. It points to the continued use of criminal and regulatory laws to restrict online expression. He had been facing 4 charges under the Computer Misuse Act arising from social media posts. Following the decision, these cases are withdrawn. But immediately, and by that day, yours truly was in court. And I was shocked by the happenings. Immediately, new charges are placed similar, using the same information, same details. And instead of bringing that matter to an end, we believe the prosecution decided to introduce these free charges to simply persecute Male Mabirizi, alleging that he broadcasted without a license. Now, this immediate substitution of new charges shows that laws are being selectively deployed against the individuals because of social media posts. And this is a gross abuse of freedom of expression. Our recommendations are that they are highlighted there, but we believe security agencies should respect and protect journalists in the course of their professional duties, including during elections or any other thing they are doing. And again, the DPP and law enforcement agencies should ensure that criminal and regulatory laws are not selectively or disproportionately applied to restrict freedom of expression. We also call upon government to review laws governing journalism, broadcasting, and online expression to ensure their compliance with Article 29 of the Constitution. And the other recommendations that you come across. Now, the other serious concern is the violation of the right to life. You all know that the right to life remains the most fundamental human rights and a cornerstone of the rule of law, as provided for in the Constitution and other treaties. We saw the Gaba murder incident where a 38-year-old Okelo Nyum stabbed and killed 4 children, which was a concern. The trial was conducted in a mobile court at Gaba, which we criticize, of course, because of failure to follow due process. Again, we've witnessed several others. The Lungu Jadabo murder incident at a hotel where we saw 2 people who were murdered. We know the Chanja murder incident of a popular TikToker and entrepreneur, Diana Namulinde. There's the Mukono murder incident of Pamela Ruth Mwebaze, University Director of Studies. And these murders are concerning. We believe there should be something, attention needs to be given. And even as we speak, we've seen continuous ones that are happening. And much as we've seen efforts to have these people prosecuted and some of them, taken to courts of law, we still believe a lot of attention has to be given to this issue because it's becoming, increasingly too much. Under the leg of transparency and accountability, which is another leg, we believe the principle of transparency and accountability is among the basic principles of the work in public administration that really should focus on building systems that are democratic and based on the rule of law. But we have concerns with, one, the NGO suspension and shrinking civic space. Now, during this reporting period, concerns arose regarding the exercise of regulatory power over civil society organizations and the impact of such actions on transparency, accountability, and civic participation. I earlier talked about the NGO Bureau suspending operations of several civil society organizations that are majorly, usually monitoring, reporting, and pushing for accountability. Now, we know that these affected organizations challenged the basis of the suspension, raised concerns regarding the process through which it was done, but up to now, it has not been addressed. So these are organizations that are majorly engaged in human rights protection, governance, election observation, civic education, and accountability work. So the important questions being raised are those of transparency and accountability, of regulatory decision-making, and these actions, administrative actions that are causing challenges. Now, of course, this suspension also had severe implications for fundamental rights, including freedom of association, and the right to participate in public affairs under Article 38 of the Constitution. So these rights are very essential for a functional democratic state or government. Now, also the shrinking of civic space was further illustrated by several arrests and detention of outspoken human rights defenders. We saw Dr. Sarah Virete, the Executive Director of Center for Constitutional Governance, on 30th December, being arrested, detained, and up to, I think at the beginning of the year, 2nd January, produced in court, denied bail. These days, getting bail in court is celebrated. Or Uganda. This is a constitutional right, but we celebrate bail. But we saw this as a direct attack and a deliberate, intention to silence these freedoms, especially the human rights defenders. Now, a transparent and accountable governance system requires that regulatory institutions exercise their mandate independently and provide clear justifications for the decisions that have been made. Now, on the aspect of due process and climate legality, we also had serious concerns under that. I mean, due process, I'll talk about the right to legal representation and the right to bail. This has been seen, I've already probably mentioned it, the fact that our Constitution, Article 28, provides for a right to a fair hearing, where the person is entitled to legal representation. We've witnessed an interesting trial of Colonel Dr. Kizza Besigye, who has had challenges with legal representation. The lead counsel, Martha Karua, was denied entry and declared persona non grata. We saw another lead counsel, Erias Rukwago, also, arrested or abducted and arraigned in court, charged with various offenses. And Dr. Kizza Besigye and Raj Lutare continued challenging this in their, proceedings, in their trial, saying we're entitled to legal representation of our choice. That notwithstanding, we are seeing serious issues with that. On the aspect of a right to bail, right now it is even very hard for any person to say it is settled law, because you no longer have settled law in the area of bail. There's a lot of uncertainty. It's almost, bail has become a privilege, because it looks like it does not matter what someone has to do, what someone does, what a lawyer prepares for a person to be granted bail. Even when someone satisfies all the requirements as underlined in the law, the decision comes from somewhere else. Now, people are using this, as a punishment, and we feel it's really a challenge where the courts are either not acting independently, or they are, not doing what they're supposed to do. Even when someone, we know it is the discretion of court, but even where the person, the applicant, is deserving, it is almost impossible to have that person get bail. So we believe this continued detention of accused persons pending trial, it should be an exceptional matter for someone to be kept inside prison, especially where someone has proved all the required, has given all the requirements, and is deserving. Why not grant them bail? So these are concerns, and we have recommendations there also to the judiciary specifically, which are in our report. And again, we have pending pertinent legislation. We've been thinking about this. It's also another issue under this leg. The legal aid bill, which has been pending. I will not say much about this. We know the implication and how important it's equally important. How many Ugandans can afford services of a lawyer, and if you're preaching access to justice. But then we increasingly see some legislations that are brought to Parliament are being fast-tracked and passed very fast. But some of these important ones are not even considered. So that shows where we are. Incidentally, these are laws, these are bills that touch, human rights aspects. We have the Human Rights Defenders Protection Bill of 2020, which has also been lying there, ignored. I think it has gathered dust. The Sexual Offences Bill of 2019, the Witness Protection Bill of 2015, as well as the Marriage Bill of 2024. Now, during this period, what has ULS done? And this will be the brief, almost the last part. In response to the rule of law and human rights in Uganda, ULS, under the leadership of the Radical Nuba, undertook a range of interventions aimed at promoting constitutionalism, protecting human rights, strengthening access to justice, and holding duty bearers accountable. Now, these interventions have included, a lot of advocacy. We do strategic advocacy, public interest litigation, legal awareness and community engagements, media advocacy, legal aid and pro bono, and engaging with key stakeholders through various platforms. We believe that while doing this, we continue to exercise our mandate under the ULS Act to ensure that we reinforce the rule of law and promote equality. Now, at the beginning of the year, we did launch what we call the ULS Election Watch and Rapid Response right here. And it was at a time where there was a lot of challenges, internet shutdown, suspension of other civil society organizations. And we did share our report because we saw all these people being arrested, at least had lawyers to represent them on pro bono across the country. And also were able to document to observe and document the happenings during the electoral period. You saw us launch that, and we do have a summary of the rapid response interventions by the districts, where our lawyers, the members of the bar, came out to represent some of those victims in the report. Again, we also offered legal representation and support for victims of human rights violations, several of them. And you might also recall that on the 26th of June, on the 2nd of June first, we announced a lawyers' strike in solidarity with victims of torture. And this was after we had just received a decision from the Constitutional Court of Farouk Muhammad, which nullified provisions of the Human Rights Enforcement Act dealing with torture, which we felt was, a slap in the face, and also like moving 2 steps forward and 10 back. So on the 26th of June, in solidarity, we had a lawyers' strike, which you saw across the country. We've continued to undertake public interest litigation. There are several cases we filed, both domestically and regionally, rising out of these aspects we saw. You will see them in the report. And then we've also contributed to legislation and gave our opinion. You remember when we had the protection of sovereignty bill presented in Parliament, we did do some advocacy, try to advise in accordance with our mandate. Unfortunately, the law was still passed nonetheless, but we are still doing advocacy around that.